Welcome back to Canadian Justice, where we're talking about the lawsuit against the region of Waterloo for a bylaw that they enacted that prohibits bullying and harassment. And we're chatting with the lawyers who argue that that bylaw is unconstitutional. Now, Chris, one of the arguments you are making is that this Waterloo bylaw may actually be outside the scope of the region of Waterloo to even enact, because essentially it's acting as criminal law. Maybe you could tell us first, what are the penalties for this bylaw, and then how that contributes to the question of whether or not it's actually criminal law, which regions, municipalities can't enact.
Yeah, absolutely, Christine. So, as we talked about before the break, what the bylaw does is it prohibits objectionable or unwelcome conduct that could reasonably cause offense or humiliation. And the fines that are imposed when it is decided by either a bylaw officer or potentially a police officer that conduct has taken place range all the way up to $5,000. So we're not necessarily talking about jail time here. Obviously, if someone were to be fined and then were to refuse to pay the fine, that could result in jail time. But that's not one of the penalties that has been imposed by the bylaw. But nevertheless, that is a very significant levy to impose for conduct that we say in another part of our argument is not a reasonable limit on freedom of expression. But as you've alluded, there's a more fundamental issue here, Christine, about what municipalities are or are not allowed to do. Some of your viewers may be aware that municipalities are what we call creatures of the province, which means they don't exist independently on a constitutional level. It means that provincial legislatures create municipalities and then delegate some of their powers to them. So essentially, a municipality cannot exercise any authority that a provincial legislature itself does not possess. And when we're dealing here with prohibitions that are essentially, for all intents and purposes, criminal prohibitions, the case law and the rulings that have been handed down by our courts, including the Supreme Court of Canada, are very clear that criminal prohibitions the power to create criminal law in the form of criminal prohibitions is a power that lies exclusively with the federal parliament. This isn't to say that provincial legislatures or municipalities can't regulate things surrounding property and civil rights, but to go after the content of expression itself, where what's being targeted is not actually interference with property or civil rights, but with content of expression that is deemed in and of itself to be harmful, that is essentially a criminal prohibition, and it therefore falls outside of the municipality's powers.
Josh, another argument that you're going to be making about this bylaw is that it violates the charter right to freedom of expression. Tell me about that argument.
Well, the right to freedom of expression protects all expression. It's content neutral, but there are some limits that the courts have been willing to accept, including the Parliament's criminal hate speech laws. But the Supreme Court has been clear that those are only available for the most extreme forms of the emotion described by the words detestation and vilification. And, it has to rise to a really high level of sort of abhorrence and delegitimization of another group before it can be outlawed without violating freedom of expression. And they've also been clear that speech that, merely ridicules, that affronts people's dignity, that is hurtful or that is offensive, speech we might call lawful but awful, that can't be criminalized in Canada without violating freedom of expression. And, people are sometimes surprised that, offensive speech is constitutionally protected, but it does make sense because we know throughout history that the powers that be often will say a speech is offensive in order to shut it down, to shut down their political opponents. And it becomes really difficult in a democracy to have the conversations that we need to have if we can't, sometimes going to rock the boat or that other people might consider offensive. So this is protected speech. I think the Supreme Court has been pretty clear about that. So even if they did have the power as a municipality to engage in this sort of criminal type of law, it would still not be compliant with the charter.
Now, Josh, correct me if I'm wrong, but I believe there's Supreme Court of Canada case law that specifically says offensive speech is protected speech. And it's the offensive speech that gives the right to freedom of expression its value, because inoffensive or benign speech never gets silenced at all.
Yeah, you're absolutely right. So the Supreme Court's been saying that for decades. They said it again fairly recently in the case of a Mike Ward, who is a comedian who made some off-color jokes that were offensive. That's true. Like, if we all agree on something, that expression doesn't need special constitutional protection. It really
Absolutely.
there is there for the offensive speech.
We've got to go to break now, but we'll be right back.